Number 24, DCCR 0917-0918, 25 DCCR 1436, 1437, and then 24 DCCR 0407. Mr. Batiste is charged in the first two cases with murder, the second two with manslaughter, and the last with possession of marijuana. And what is the announcement?
Judge, we're still ready for trial. So
the state's ready for trial as well, Judge. We would prefer to proceed on the felony possession of a marijuana case first. I understand that if there's pushback from the court on that, given the fact that it's a state jail.
I'm not doing that. There's no way I'm going to try a state jail felony on top of the other cases. So what are we actually? This is just an announcement. Did we get off the trial docket?
Yes, Judge.
Remind me, please.
We tried this case. We had a hung jury.
Yes.
And the state elected to re-indict as a manslaughter using the same theory essentially as before. But the challenge is, of course, I think you said it on a review or whatever this is, because that's essentially a totally different charge than the fentanyl murder statute that we were arguing about last time.
And I'm fine. Obviously, I would, if the state's going, I guess I'm a little confused. The two murder charges are still pending, and typically when something,
I filed dismissal on those.
Perfect. Okay, so actually, we're just looking at the two manslaughters and the possession of a marijuana case.
That's right.
So I would, let's get it set then for a trial on the two manslaughter cases, and then see where we get from there.
Judge, the state's also filed a motion.
Yeah, let's talk about that. So, Mr. Batiste, Mr. Coleman has filed a motion asking that I order you to act in a certain way out at our jail and to follow the rules and all of those things, which you should be doing anyway. I feel like we've probably already had this conversation, but what I can do, and here's what I don't necessarily want. I don't disagree with Mr. Coleman a single bit. You can ask Mr. Gertz, you can ask anybody that's been in front of me about how I feel about what is going on at our jail and how disrespectful inmates are being to the staff out there. And I'm doing whatever I can to try to get through to you all, because it can make things much worse. Much worse. Number one, if you go to trial on the manslaughter and you're found guilty, the jury's going to hear about all of it. They're going to march these correctional officers in here, and they're going to say what you've been saying to them, that I'm not going to say today because a lot of people are watching. But you know what you're saying. You know how you're acting. I can promise you, Mr. Gertz is embarrassed for you because you don't help him help you by acting this way. Does that make sense? You're not one of these kids out there. How old are you?
26.
26. So typically I'm dealing with 17, 18, 19-year-olds that are out there acting crazy. You're too old for that. What I don't want to do, Mr. Coleman, though, is cause the jail more grief by holding him in contempt and making him stay there even longer. Here's what we're going to do. We're getting the case set for trial on the manslaughters. We're going to get those tried. I'm not sure what I will do if you violate this exactly. I can't tell you right now, but I am ordering you to refrain from calling names. And if you need me to tell you everything, I can. If I need to be specific, I'll be specific. Because what I don't want you to come in here and say, well, I didn't say bitch, I said whatever. You know what I'm saying?
Yes, ma'am.
Behave. Don't call names. Don't tell them they don't have rank. Don't tell them I get what I want, B. That's not how you talk to somebody who's just going to do their job. They're just trying to go do their job and go home. and they got to deal with you and all the other people out there that are acting like idiots. So I'm going to order you to not do that. What that means is if you violate that order and do it, and I get more incident reports, Mr. Coleman will ask me to hold you in contempt. And what I can do for every single incident, for every name you call, for every time you get written up, for every time you don't follow the rules, I can hold you in contempt and I can order 6 months. And then I can stack 6 months for every name. Every time you say it, I can stack it, stack it, stack it. Do you understand?
Yes.
So you are now court ordered to follow the rules, which I shouldn't have to do, but I am. Okay?
Yes.
So I will set these cases for trial at the very next trial setting that we can get them on, and we'll go forward at that time. All right?
Thank you, Judge.
You can go back with the bailiff.
Yes.
I need the certification. Who's this? Kaylin Douglas. Yeah. Kaylin Douglas. It should have been with, oh, never mind. Did I print it? Nope, I haven't yet. I kept it. That's why. Okay. All right. So just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF, but I can't not stick to my word. I told probation when you were here. I told you when you were here. No more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 6, 7. What day were we here? Dozens, at least. The sentence date was supposed to be, the sentence date was November 18th. So since November 18th, you've been caught with looks like kind of a makeshift tattoo needle. We've got 1, 2, 3. Four or 5 at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray, horse playing, smoking. I mean, it's just...
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
No, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. That I'm just reminding myself of all. I mean, the fact that you got this in the first place, because we went through. I have it all marked off on this PSI. Your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow simple rules. So I am going to, let's see. So I have documents here on this tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I go along with this agreement, that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Find you guilty of obstruction or retaliation, a 3rd-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about a year and a half, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right? You can go back with the bailiff. All right, you are Heyman Brandon Jr.?
Yes, ma'am.
This is cause number 21-36605. Mr. Brandon is charged with the first-degree felony offense of murder. Looking back at the file, which I'll take judicial notice of, it looks like Mr. Brandon was previously found not competent to stand trial and then sent to the appropriate facility. That looks like the Terrell State Hospital. And let's see. So are we now? I have received a report dated January 20th of 2026 from that facility with the finding that Mr. Brandon is now currently competent to stand trial. That evaluation includes a evaluation report, trial competency evaluation report that was prepared by a Dr. Jasani. The finding in that is, again, that Mr. Brandon is competent to stand trial. And that he is able to move forward with his criminal proceedings at the present time. That was also signed off on by a Dr. Lampley as well. So I have both of those doctors saying that he was currently competent to stand trial. We got him back and we're here now. So what is the announcement?
Your Honor, what I did was I kind of challenged that. I thought I was going to challenge that. So I sent Dr. Capon out because we were having a hard time communicating even when he got back to the jail 3 weeks ago or so. Dr. Capon went out also corroborating the fact that he feels like he's also competent.
Okay.
So I reached out to Mr. Smith, who is still dealing with the family. I'm still dealing with him, which is going to take a little time. I have a insanity evaluation that's also being done by Dr. Capon. If we could have a somewhat of an extended announcement, then we could come back and be prepared. I'm literally asking possibly, Governor Smith, for possibly a bench trial. The thing.
So let's do this. What I'll do then, based on that report, as well as the your statement that Dr. Capon is also going to, and I believe I do have a copy of Dr. Capon's report. It was probably meant to be sent to you, but it was sent to the court.
I asked them to send you a courtesy copy so we could kind of see where I was thinking.
Any objection to me taking that into consideration with regard to competency as well?
There you go.
So I'm also going to take judicial notice then of the competency evaluation report prepared by Dr. Capon. It's dated February 12th of 2026. Again, it has the finding that Mr. Brandon is competent to stand trial. Based on both of the reports from Vernon's as well as Dr. Capon, I'm going to at this time find that Mr. Brandon is competent to stand trial. And what I'll do is I'll do about a 45-day reset to see where we get at that time, and then we will see if we can get an announcement at that point.
Yes, sir.
All right. You can go back with the bailiff, sir.
Great.
Good morning. Are you Khalil Bradley Harris?
Yes, ma'am.
And Mr. Bradley Harris is charged with unlawful possession of a firearm by a felon in cause number 25 DCCR 1334. And Mr. Lane, what is the announcement?
Your Honor, I came into the case late and went over discovery. I apologize to Ms. Walvino. I have a media request, but the main officer, Miss Champagne, does not have her body cam. As she says she has her body cam, there's like 8 videos of this stop. And it's a very important video because it shows